Straits brings legal and business insights at the intersection of the shipping and energy sectors. This podcast series offers trends, developments, challenges and topics of interest from Reed Smith litigation, regulatory and finance lawyers across our network of global offices. If you have any questions about the topics discussed on this podcast, please do contact our speakers.
Hi everyone, thank you for joining our latest episode of the Trading Straight podcast here at Reed Smith. My name is Susan Rita. I am counsel in the asset finance team in the London office, and I'm joined today by Liam Hart, and I will let Liam introduce himself briefly.
Hi everyone, my name's Liam Hart. I work in the projects and construction team in London, and I specialise in disputes in the construction and engineering industry, including disputes with respect to ships and maritime structures.
Right. So we'll have a little chat about a couple of topics. In general, the subject matter today is shipbuilding. And I think certainly from my perspective, the shipbuilding market seems to be very busy at the moment. Container ships in particular and LNG carriers demand is currently very high. And reportedly, there are quite a lot of new orders being placed all the time. And every time I open trade winds, there is somebody ordering some massive box ship from somewhere. Now, I suppose there's a lot of fleet renewal seems to be going on, which is probably contributing to this trend. Clearly, there's a big drive towards greener shipping in a lot of ways. Older vessels kind of unable to use alternative fuels and are no longer really that attractive to owners. It's making it more difficult and obviously more expensive to comply with increasing environmental regulation, and nobody really likes to have to spend money. So we're seeing a fair number of owners coming up with plans to renew their fleets. An example of this, I suppose, would be the IMO 2020 regulation that requires that there's a limited amount of sulfur present in fuels for ships. And while we've seen a little bit of activity in terms of owners retrofitting scrubbers onto existing ships, that isn't necessarily really going to be enough for everybody. And there are other ways in which you can make your ships greener and better performing. So increasingly, owners are looking to renew their fleets. And I suppose the other factor that's pushing some of this development that we're seeing reported is the ability to finance your ships. Now, recently, one of the big developments we've seen in the finance market, which is what I focus on, is that a lot of the big name ship financiers are signing up to the Poseidon Principles. And this is basically a framework of principles whereby the banks are looking to integrate environmental and climate considerations into their lending decisions, into their documentation, and have a kind of combined view towards how to encourage ship owners to decarbonize and be more environmentally friendly. A lot of the big names have signed up for these principles. Obviously, they're not binding, but ABN AMRO, DNB, ING, big ship finance lenders have all signed up, and we're seeing in loan agreements increasingly specific provisions that require borrowers to comply with the Poseidon Principles. So clearly, indirectly, for owners, there's benefit in renewing their fleets and getting ships built that are more compliant with environmental requirements, and makes it easier to also then borrow money against your ship if you can demonstrate that you're acting in an environmentally friendly way and have an interest in that. Ultimately, I think, though, one of the reasons that adds to this busy order book is also obviously the COVID-19 pandemic. A lot of shipbuilding sort of stopped, ground to a halt, especially in China and at the beginning of the pandemic, where a lot of projects just obviously couldn't proceed at all. So there's a little bit of the backlog being contributed to by the pandemic, and some of it is really just this increase in demand, especially for container ships and alternative fuel vessels. That seems to be driving that. And I at the moment doesn't seem to show any signs of slowing down. I'm no market expert, but certainly it's being reported constantly in the press that something new is being ordered. I guess Liam, I'd be interested to know your experiences of the pandemic and how that's affected the kind of disputes area and what you've been seeing recently.
Thanks, Susan. Well, we've seen a really large uptick in the number of inquiries we've had in cases that we're involved with that involve force majeure principles. So I'm going to talk about that first, but just to give some structure to what I'm going to speak about, I'm going to focus on 3 issues or topics. One's force majeure, 2, time bars and notification provisions under the contracts, and 3, good faith obligations, because we're seeing more and more cases that involve those 3 issues. And I'm just going to wind up by giving sort of 4 do's and don'ts when you're involved in a project and want to make sure that you're in good shape in the event that you fall into a dispute. So first topic, force majeure. So as many of you listening will know, force majeure is a principle whereby in the event of an unforeseen circumstance that neither party could have prevented or allowed for, one of the parties to the contract can rely on contractual clause to avoid its obligations under the contract. And it's very important to stress that this is, under English law, a matter of the contract. There's no general principle or implication of the term that says that if a situation changes drastically to the disadvantage of one of the parties, that the disadvantaged party should be allowed to avoid its obligations. Now that's what English law says about this. It's very different as a matter of, for example, French law or other civil code jurisdictions. And we often deal with civil code lawyers who are surprised to find that even though that there's been a very dramatic change in the world economic circumstance brought on by COVID, that doesn't necessarily mean people can avoid their obligations under the contract. And as a matter of English law, what you have to do is look at the contract and see what the contract says in relation to, these kinds of events. And as many of you will know, in standard form contracts, it's quite common to say that in the event of a pandemic or an epidemic, there will be relief from having to deliver a vessel within a certain time period, or you'll be entitled to additional cost, whatever the contract says. But the analysis has to be, what does the contract say? It's not the case that you can simply claim force majeure. It doesn't exist in the ether. It exists as part of the contract. Now, there is an English law principle called frustration, which says that if the performance of a contract becomes impossible, i.e. you simply can't do it because, the physical circumstances don't allow, then you can avoid your obligations. But that is very rare. I mean, the case law deals with things like, buying a ticket to see a performance at a concert hall that burns down. It's that kind of stuff. It's something that you physically can't do. So frustration really isn't something that you ever see argued very much in English courts because the threshold is so high. But we are seeing a lot of inquiries to do with force majeure. We are seeing a lot of inquiries from people who don't necessarily understand that force majeure is a creature of contract. So any kind of analysis as a matter of English law has to focus on the wording of the contract and doesn't exist kind of outside of that. Now, because force majeure is a creature of contracts, it ties in neatly with the second topic, which is time bars and notification under contract. So as a matter of many construction contracts, if you want to claim force majeure or you want to claim relief of any sort or additional payment, you will need to give notice within a certain defined period of time. Now, if you don't give the notice within that defined period of time, and the contract says that you lose your rights in circumstances where you don't give the notice, then you will lose your rights as a matter of English law. English law is very draconian in this sense. So if the parties have said in express terms in the contract that if you don't give notice of an otherwise meritorious claim within a certain period of time, if you don't give the notice, then you lose your claim. Now, there are certain arguments in reality, in practice, that you can try and use to avoid that draconian way that English law works. But even if you have to rely on those arguments, you're already very much on the back foot in a dispute, because you're not, say you've got a great claim, but you haven't given your notice, you have to wade through the initial skirmishing to dealing with notice arguments before you can actually get to the meat, the substance of the dispute. So it's very, very important that people comply with notice provisions. And the key thing really is that English law and most other common law systems, I think it's fair to say, will expect that sophisticated commercial parties will be bound by what they've written down in their contracts. The underlying philosophy is that if you have decided to bind yourself in a certain way in a contract, that you're not going to be able to try and avoid being bound in that way further down the line. And that leads on to the third topic that we've seen quite a lot of inquiries about and dealing with more on a regular basis, which is good faith obligations. So it always used to be considered that there was no implied duty of good faith in an English law contract. And that was something that would often surprise civil code lawyers. They would find it very surprising that there was no implied duty to act in good faith. But that was the English law. Now that's changed in recent years because of recent authorities, some of which deal with the shipbuilding industry. And one judge in particular, who was in the lower courts, has recently been promoted to the Supreme Court in England. He's very keen on this idea that you have an implied term of good faith in English law governed contract. And so that means that whereas force majeure, and time bar / notification cases, in a sense, are relatively straightforward to deal with in the sense that you're looking at what the contract says and construing the express words of the contract. Increasingly, we're seeing a situation in relation to good faith where there's a kind of nebulous sense that there's potentially a good faith obligation that's implied into the contract. And it's allowing people to try and argue that there are a variety of obligations that stem from the good faith obligation that aren't necessarily spelled out in chapter and verse in the contract. So it's less kind of clear cut than the position was previously. And added into the mix is because it's so recent, it's unclear what the exact parameters of this good faith obligation. Now, you're seeing a lot of people trying to use these kinds of creative good faith obligation arguments in arbitrations, which are governed by English law, because they realize or they recognize that perhaps English courts won't be as amenable to have something very wide, but potentially an arbitrator that comes from a common law tradition, they may be more willing to see good faith obligations argued. So in summary, we're seeing a lot of cases that involve arguments about force majeure. We've seen a lot of cases which involve arguments relating to time bars. And increasingly, we're seeing good faith obligations, often in arbitration or various kind of tiered dispute resolution procedures under shipbuilding contracts, argued, even though the arguments are often somewhat woolly and a little bit nebulous. I thought it'd be useful to kind of round up by looking at do's and don'ts, 4 kind of key do's and don'ts when you're on a project, to prepare yourself potentially for a dispute. And number one, it's a statement of the obvious, really, but make sure that you do your homework. Make sure that you're confident that you have the information when you go into the contract that allows you to divide the risk appropriately or protect yourself under the contract appropriately. And that's really important, especially in terms of first of a kind projects or where people are having ships built in new jurisdictions or with new partners. So many of the issues that I deal with relate to first of a kind projects, technically complex first of a kind projects. So the first time things gets done, it's often difficult for people to do it correctly, especially if you're moving to a new jurisdiction where you think you're getting a really great, cheap deal. If you're the employer from a contractor, and the contractor might not necessarily have the expertise or the experience in that particular field. So homework number 1. Number 2, follow the contract, especially in relation to time bar clauses and giving notice of potential claims. So often, we see otherwise meritorious claims become unnecessarily difficult because people haven't given the requisite notice. And what often happens is when people enter into these contracts, even though they've had months and months of quite tortuous negotiations, they refuse or are reluctant to actually operate the notice provisions because they don't want to antagonize the other party to the contract. They say, oh, well, the project is going quite well. We want a good commercial relationship. We don't want to rock the boat by giving notice of potential claims because that might alienate the other side. Well, that sounds good in theory, but in practice, if you do not give the requisite notices of potential claims, then ultimately you could be losing those claims. You could have a meritorious claim that is just dead in the water because you haven't given notice. People often have very rosy relationships early on in a process, but that can deteriorate. And most fundamentally, I suppose, you've potentially spent weeks or months negotiating these contracts, including the notice provisions. Why is it, having done that, would you just bin off or forget the clauses that you've negotiated? It kind of doesn't make sense. So that's something that you can really hammer home to the side. We all know where we stand if we just operate the contract that we've agreed. So I would say that's probably the most important of the points I'm going to make here. Number 3, keep accurate records. So often we have to try and creatively come up with arguments or ways to evidence claims where there's been an overrun let's say there's been an overrun in the construction cost of a ship. And we know, because we're paying for it, let's say we're the employer, that we're paying more than we'd anticipated. But it's difficult for us to work out where the money's gone. I remember one case I was dealing with in particular that was a target cost contract for the construction of a ship. And the ship was way, way over budget. The lawyers were brought in very late in the day to try and help the employer who was having this ship built in a yard in Europe, actually. And the records just weren't good enough to allow us to put forward the disruption claim that we otherwise would have liked to. And it was something as basic as the records for people clocking on and clocking off the yard, the labour records. It's very difficult to see whether Joe Bloggs or the continental equivalent of Joe Bloggs was actually on site at the yard doing particular tasks at a particular time. And it's very, very difficult for us to create a disruption claim. So bear that in mind. And fourth, involve lawyers early. It doesn't have to be external counsel, could be your in-house team. But I can't stress enough how important it is to involve lawyers early. That will help you with notification and time bar and so on, and understanding the records that you need to keep. But I think probably most importantly, it allows you to maintain privilege in the communications that you have once you realize that a project is potentially starting to go wrong. That is so important if you are thinking of preparing documents that are lessons learned documents or briefing notes to the board, say, to explain why the project is going wrong. I mean, I have worked on a number of projects where we've been brought in, later in the day, and we find that one of the engineers, say, has prepared a document that sets out in a kind of warts and all way why it is the project has gone wrong, including good and bad for our client. Now, that document will potentially be discoverable in an arbitration or in litigation. And in those circumstances, you can find that you're in a situation where you're kind of damned out your own mouth. It can be very, very problematic to deal with those kinds of documents. So if you involve lawyers early, you can maintain privilege in communications. You can have those discussions as to how you will do things better on this project or how you do it better on future projects. But you won't face a situation where that kind of document ends up in front of a tribunal or a court further down the line. So that's a very important point as well. So to recap, ensure you take special care when you're dealing with first-of-a-kind projects, new jurisdictions, and so on. So do your homework. Secondly, follow the contract. Thirdly, keep records, accurate records. And fourthly, do involve your lawyers early. Doesn't have to be external counsel, can be your internal counsel, but make sure they're involved because it will help you in any number of ways, including with respect to maintaining privilege in your documents.
Yeah, I think those are all really interesting points. And I think that especially the part about the lawyers, and as much as, obviously as much as we like to do the work, the most important thing is just that somebody is looking at it. I mean, a lot of times, by the time a shipbuilding contract crosses my desk, it has already been negotiated and the parties have spent, weeks or months talking about the specification and the technical stuff. And then, a dispute arises or an issue arises under the project, and they realize that, other operative parts of the contract are just not workable. I had clients come to us and say, okay, we need to terminate the shipbuilding contract because the shipyard is insolvent and there is actually no ability in the contract to do that. So the earlier you can get your lawyers to look at it, the better, because the lawyers will look at the stuff that the commercial people don't necessarily want to worry about, but it's usually the stuff that then becomes the most important when you come to a dispute.
Absolutely. And just to pick up on that point, I think it's really important to make sure that you don't just agree your dispute resolution clause at 5 to midnight when you're closing a deal. It's important to think about, worst case scenarios. What tribunal do you want to be in front of if things do go wrong? And having, a disputes lawyer spend half an hour looking at, your dispute resolution clause can save you years of expensive legal fees. So I think that's very important as well.
Yeah, absolutely. Okay, thank you very much for listening, and we hope you found that useful and look forward to you joining us for our next Trading Straits podcast.
Trading Straits is a Reed Smith production. Our producer is Ali McArdle. For more information about Reed Smith's energy and natural resources or transportation practices, please email tradingstraits@reedsmith.com. You can find our podcast on Spotify, Apple, Google, Stitcher, and reedsmith.com, and our social media accounts at Reed Smith LLP on LinkedIn, Facebook, and Twitter.
This podcast is provided for educational purposes. It does not constitute legal advice and is not intended to establish an attorney-client relationship, nor is it intended to suggest or establish standards of care applicable to particular lawyers in any given situation. Prior results do not guarantee a similar outcome. Any views, opinions, or comments made by any external guest speaker are not to be attributed to Reed Smith LLP or its individual lawyers. All rights reserved.